on with her presentation.
Good evening, everyone, and thank you for inviting me. So that first slide was actually my older daughter, Sheridan, who's 26. So just so you know, so both my girls have Down syndrome, 21, 26, and they are my biological children. Anybody that has multiple were asked that question. And that's a picture of me. We can go to the next slide. So I wanted to tell you about the ARC. So what I've been asked to do is talk about futures planning, including special needs trust and ABLE, spend an hour on the topic and save the last 30 minutes for questions. So I'm going to roll through this presentation, all right, without a lot of extra chatter. The ARC, if you don't know what we are a national organization that has a mission to promote and protect the human rights of people with intellectual and developmental disabilities, and actively support their full inclusion and participation in the community throughout their lifetimes. I'm at the ARC of Northern Virginia, which is our local chapter. We have 23 chapters in Virginia. Maryland has 10 chapters, and then the ARC Maryland, so 11 in all. So there are sister chapters, and I work closely with 5 of them at this point. We're always expanding to help with special needs trusts and futures planning. If you're wondering how we're funded, just like the Down syndrome group, through direct, or not through direct services. I don't know if you guys provide that because I didn't go in depth on your website, but membership, grants, fundraising, contributions. So consider donating to the Down syndrome network. Next slide. Our trust program has over 20 years of experience managing special needs trusts in Virginia, Maryland, and Washington, D.C. So our documents have been viewed and approved by the Attorney General's office in Maryland as well. So even though our chapter is located in Northern Virginia, we are the ARC in our region that has a special needs trust program. So we're an authorized nonprofit to manage special needs trusts, plus other services that we do. There are more than 660 chapters, state and local chapters in the US, and we're actually the world's largest community-based organization of and for people with intellectual and developmental disabilities. Our special needs trust program serves any disability, whether it's cognitive, mental, or physical, as defined by the Social Security Administration, okay? Next slide. There we go. This is just to show us who we are. So there's actually another member of the trust team. That's me and Trini, Evelyn, Allie, and Karen. And we have 2 full-time positions open. We're hiring 2 more people. Go to our website if you're looking for a job. It's all remote at this point. And then our trustee. So we manage the Special Needs Trust Program. Our trustee, the financial institution with which we work, is Key Bank. And those are 2 of my main contacts there. And the bottom row of gentlemen and 1 woman is our foundation of the ARC of Northern Virginia. I report to them and they oversee the Special Needs Trust Program and our endowment. Next slide. So what is futures planning? I love this logo or this vector. It's a lot of pretty colors, but it tells us it's a holistic approach when you're planning for the future of your child. And when I say child, I mean little child or big child, right? Child or adult child. When you're planning for your child with disabilities, there are many different areas that we need to consider. Next. So what are we going to talk about tonight? Briefly, we're going to go over letter of intent. You can just go through these. Yep. Legal authority, government benefits, estate planning tools, special needs trusts, and ABLE. And financial planning. So I'll really spend most of my time on special needs trusts and ABLE so you have a better understanding of those 2 financial vehicles. Next slide. So letter of intent. What is a letter of intent? Well, it's a document that parents usually write, or the primary caregivers, about the individual with disabilities, so that when we are no longer able or willing to care for our children, the next person can come along and pick up that document. I used to have a binder here on the table. I just moved it away. Pick up that document and read it and say, okay, who is this person? What do they like? What are their dislikes? What did the parents intend for them? What do they want to be doing? And it reviews those many areas, 16 plus areas on that pie diagram, right? We look at finances, we look at health, we look at advocacy, we look at housing and employment, etc. And it's a guidance document. It's not a legal document, and you own it, so to speak, and update it when it's necessary. We always recommend going back to review it, usually around the birthday of the person with disabilities. That's a good reminder to say, hey, is there anything else I need to be adding to this letter of intent? Next slide. So legal authority, this is in regards to the individual with disabilities. This goes along the spectrum, so to speak, of what can be put in place in order to help our children with decision making. Supported decision making is what we do every day of our lives, whether it's me or somebody else. You know, Brooke, do you like this scarf or should I wear the pink one? Right? So I'm asking for support in some decision making, right? Just like when you're teaching your children, okay, do you want to do this or do you want to do that? Those are your choices. And I think as parents, we're doing that automatically. And oddly enough, people spent millions of dollars to find out. There's research that says that when you teach people to make decisions, they usually make better ones. Imagine that, right? I mean, seriously, they could have just given us the money. We could have told them the exact same thing. So that's what we are doing in our everyday life. And different states are passing or attempting to pass legislature that supports supported decision-making as an actual legal vehicle. Authorized representatives for Medicaid, whether it's state plan Medicaid or a Medicaid waiver, home and community-based waiver services. A representative payee for Social Security. So Social Security Administration, I'm the rep payee for both of my daughters. So they cannot manage their finances on their own. We do practice supported decision-making, but I'm also there to oversee the money that they get on a monthly basis from the Social Security Administration. Power of attorney is another legal document that can be put in place to help them make decisions. There's a statutory power of attorney in Maryland, and then you can also create a durable, 2 words, A and then DURABLE, a durable power of attorney that where you oversee finances, potentially healthcare decisions, because you want to have an agent who can assist them whenever they need it with decision making, and actually have a legal document in your hand. Sometimes that's helpful depending on who you're dealing with. The advanced medical directive speaks directly to that. Do not resuscitate or keep me alive as long as possible, or do put me in any type of experimental program that NIH is running, because I'm really happy to, try different things, or, shut off the machine if I'm not breathing on my own. So it's important to have an advanced medical directive for our adult children. Remember, up to the age of 18, you as parents, if you're the parents, you are automatically the guardian of them. And at 18, they reach the age of majority. The most restrictive form along this line is guardianship. And Maryland has guardianship of the person and guardianship of the property. So one would petition the court and go to court and provide the documentation and present to the court why you believe, for example, that your now adult child is incapacitated. And it could be in a select number of areas. They shouldn't be signing contracts, carrying firearms, or driving. But I do think that they should vote, choose whom they wish to marry and where they wish to live. So that would be a form of limited guardianship, or none of the above, right? Or all of the above. And with the finances, the court usually doesn't entertain guardianship of the finances if the individual has less than $2,000 in their name. But again, that's a court process, and it's a little more, I just want to say, complicated than any of the other options on the list. And someone could have a mix and match of these different things, right? So I do supported decision-making for my girls. I'm their authorized representative for Medicaid. I'm the representative payee. And I also have a financial power of attorney as well as a health proxy for them, which includes the advanced medical directive. So what we've put in place for our 2 girls are the first items. We've not sought guardianship because it's a legal process, and that's always something that one can choose to do. Once you've become guardianship and there's a court order through the court, you're then required to go back to court if you want to change anything in the document. Yes, next slide, Brooke. Means tested government benefits. Now, some of you may have heard about that a $2,000 threshold. What is that? Well, if someone is applying for Medicaid, home and community-based Medicaid waivers, supplemental security income, and some other benefits, but the top three on that list all have a $2,000 or right around a $2,000 asset and resource limit. That means the person should have less than $2,000 in their name in order to maintain eligibility for that service or before they apply for it. And then there are other benefits that are means tested, which I'll touch on shortly. Okay, next slide. So what is Medicaid? You think she were my favorite daughter. That just happens to be her again in another stage with her uncle. So what is Medicaid? It's a joint federal and state program authorized under Title 19 of the Social Security Act that provides health and long-term care coverage for specific groups of people with low income, right? So it's a federal and state program. Next slide. So there's Medicaid and Medicaid waivers. So Medicaid is the health insurance that people that have, that are low income with children, pregnant women, elderly, persons with disabilities, and parents meeting specific income thresholds, they may be eligible for that state plan Medicaid. For the individual, it's less than $2,000. For a married couple, it's $3,000. So there's a threshold where you have to meet that threshold and maintain it. If you have more than that, then you could potentially lose those benefits or they would be suspended. Now, a person is allowed to own their home if they're living in it. They can have one car, they can have a computer, they can have things that we would normally have. But when you have an abundance, like if you had a Rolex watch collection, then you would be over-resourced if Medicaid knew about that. And then the home and community-based services, the Medicaid waivers, these are state-specific Medicaid programs that allow for services to be provided outside of nursing homes, other facilities. So the Medicaid waivers, if a state, not every state has Medicaid waivers. If a state does have Medicaid waiver programs, there's eligibility criteria, financial criteria, that $2,000 threshold, it may be a little bit higher, and the functional criteria. So those areas are looked at when applying for a Medicaid waiver. And these are very important when our children qualify for these. And again, remember, I'm talking about little guys and big guys, right? Adults and children. When they qualify for them, it's not just health care that's paid for, but it's long-term care Medicaid. It's services for long-term care. So maybe a group home, maybe job coach, a day program, transportation, potentially assistive technology, durable medical equipment, etc., depending on how the state has defined the waivers and what services are provided under those waivers and paid for by Medicaid. So here in Virginia, each of my daughters have Medicaid waivers. So I have care attendants come into the home and help me with the girls. And whenever pre-COVID or BC, somebody said the other day, before COVID, my older daughter was in a day program and had a job a few hours a week with a job coach, and then volunteered and had a companion. So those are services all paid for through Medicaid. Personally, if I had to pay for all of that, I couldn't afford it. So this is a way, as part of the financial planning, you put together services in order to have a good safety net for your child so that they have things that they can rely on and services, and then you're able to save for them what you can afford. Next slide. Brooke, can you go to the next slide, please? Good, got it. Oh, there we go. One more, yep. So another means tested benefit is supplemental security income. So we usually apply for that when the child has reached 18 years and 1 month. All right, 18 years and 1 month is the earliest we would normally apply for it, unless one of the parents is deceased or one of the parents is disabled. At least one parent is disabled and drawing Social Security themselves. Or if the family is poor, they're living in poverty, then potentially at that point you could apply too. But general rule of thumb is 18 and 1 month. And supplemental security income is provided through Social Security Administration. It's based on financial need, functional, and diagnostic. So those three same criteria that Medicaid waivers have. Financial, less than $2,000 in the individual's name when they're over 18. When they're under 18, they're looking at the whole family's financial resources and assets. So basically, it's for people that have little or no income, and it provides cash to meet basic needs for food and shelter. And once those basic needs are met, then the money can be used for other things for that individual. So this year, it's now $700, it's either $794 or $795 a month for room and board. And you have to make sure that you provide them with a rental agreement so that they know that the child is actually using the money for rent as well. It's very important. Otherwise, they reduce it by 1/3 and the individual gets around $522 or $23 instead. So this is where I'm rep payee for my daughters for their supplemental security income. Next slide. Other means tested benefits, and these means tested benefits have other financial thresholds. It's not the $2,000 threshold of the individual. So HUD, voucher programs or Section 8, SNAP, which is the food stamps, Supplemental Nutrition Assistance Program. Legal aid is also on a sliding scale. And there's also utility and energy assistance offered in the summer and the winter to people with disabilities and the elderly. If you look on the back, if anybody still gets paper statements on the back of them, they usually explain that. So these are other benefits that can be put in place to help pay for services or reduce the amount of money one has to pay for services. Next. So estate planning and other considerations. So this is you now. This is the parent, the grandparent, the primary caregiver. You need to think about having a last will and testament. So usually I would ask, if we were in person, I'd say, how many people have a last will and testament? And it's anywhere from 1/3 of the people in the room to maybe, if we're lucky, 50%. But a lot of people don't have a last will and testament. And it is very important to have that, because you do not want to leave, you do not want to die without a will. Well, if you do and you have a spouse, okay, they're going to get everything. But when when there's a second to die, if you're married and both parents are deceased, if there's no will, it goes intestate, and the state decides who gets what. And that money then is the portion that goes to your child with disabilities or child with special needs, it goes to them, right? So you want to have a special needs trust, and in your will, you direct whatever you want to that special needs trust for the benefit of the individuals. So I'm divorced. After we divorced, Robert and I went out and had our wills redone. So when I die, what I have left will go into each of my daughter's special needs trusts. Okay. I mentioned powers of attorney. So I have powers of attorney for my girls, but we as adults need to also have our own powers of attorney. So financial as well as health care, right? Again, with COVID, people are landing in the hospital that never expected to be there, and no one can go in to visit them. And it would be really good to have an agent under a power of attorney who could speak on your behalf if you're unable or unwilling to do so, right? They don't take over control, but they're there to support you and to speak on your behalf if you cannot. So I named a good friend of mine who's down the road, and then I named 2 other friends of mine as well to be backup powers of attorney. So it's good to have a plan. You want to have some successors, right? Also, an advanced medical directive, important for you as well, right? Keep me alive, don't keep me alive is the basic. and then a special needs trust. And I'll explain that in a minute. The other thing you need to think about, other considerations, are your beneficiary designation. So if you have life insurance policies or retirement accounts or annuities, so 401k, 403b, if you have FEGLI through the federal government, or if you have a thrift savings plan, anything where there's a beneficiary designation, you want to make sure that what you were going to leave to your child with disabilities is being left to the special needs trust. Right? Special needs trust for the benefit of Joe Smith, right? Because you want that money going directly to the person's trust. There is a solution if that doesn't happen, and we'll talk about that in a minute. But the best case scenario is when you're planning, taking all of these steps to plan ahead, planning for the unexpected, right? Hopefully we don't die for many, 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 many years, but it's good to have things in place. If I could see everybody, I'd find out if anybody in here is military. So retired military, you may have a survivor benefit plan, which can be directed to spouse child. And instead of spouse child, you now name a first party special needs trust so that it's not considered as income to the individual. Put in chat if there's anybody that's military and wants me to talk a little bit more about that. Adult child support. So when the child reaches 18, if you're divorced and the child is receiving child support, even if it goes into the parent's account, at 18, it's still considered the child's. And that money can be directed to a first party special needs trust so that it does not count as income toward the individual, and it doesn't jeopardize any of the means tested benefits that they have. Okay. Just like with the military survivor benefit, it would go directly to a first party trust and not be considered income because it's irrevocably assigned and it would not jeopardize means tested benefits. And that came into law in December of 2015. And then housing options is a huge consideration. A friend of mine said to me, Mary told me that the most important thing is that our kids have jobs. And I said, I disagree. I think the most important thing is that our kids have somewhere to live, because I'd rather have my child living somewhere safely and volunteering than my child having a good job while living under a bridge. So that's my take on that. So housing is something we need to think about, right? Right now, they're housed nicely. Most of us, with most of our kids maybe are with us, but down the road, we need to be thinking long-term, where are they going to be living? And even if they are going to be living with another family member, you still have to plan with that family member so that it's not a surprise to them that, the kids are moving in when I'm gone. Next slide. So what is a special needs trust? It's a legal vehicle that provides benefit to and protects the assets of a person with disabilities and still allows that person to qualify for and receive government benefits. So it's a legal vehicle. No liens can be put against the third party trust. On the first party, there's a Medicaid lien, and no creditors can get at the trusts. So that's really important. Next slide. Who's eligible for a special needs trust? Anyone with a physical, mental, and or developmental disability as defined by the Social Security Act. So when people are not receiving Social Security because of their disability and set up a trust with us, then we ask for a physician statement or a neuropsych evaluation, something where a doctor diagnosed them and has signed off on it. It could be one piece of paper, it could be 37 pages. It could be from yesterday, it could be from 27 years ago, as long as it's been signed by that doctor and dated and has a diagnosis. Next slide. So why do you establish a trust? The main reason is to protect government benefits. We want to make sure they keep the Medicaid waiver, Social Security, housing. It's also for people who may not have those means tested benefits, but they cannot manage their money. So we have a lot of people that parents have established trust for them because they said, I know that if I give Joe $50,000 or $500,000, it'll be spent within 3 months, either by Joe or his new best friends. So by putting money into a special needs trust, it's being managed, and then you can do some long-term financial planning to stretch out those assets over a much longer period of time. And thirdly, it's to promote the dignity, comfort, and happiness of the person with disabilities. Even if they are getting government benefits, they're paying for the basic needs, basic health care, long-term care, potentially housing, food, clothing, but they're not paying for a Nike jacket or a Nike pair of tennis shoes versus a pair of tennis shoes at the Payless shoe store, or the latest iPhone. It's the special needs trust is what pays for those other things. They supplement. The special needs trust supplements government benefits. There are many, 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 many things that a trust may pay for. As long as the government benefits aren't paying for it, we then let the trust pay for it. Next slide. So what is a trust? If you click this on, there's a little video. You may need to check out the volume on your end. I don't know if by unmuting yourself, if that would make any difference, Brooke.
Can you not hear it?
Cannot hear it. We can see it.
Okay, let's see if you can hear it now.
One who has a hard time handling money themselves. In a special needs trust, the beneficiary is someone with a disability.
Turn it up a little.
Here's how the process usually works. In most trusts, a grantor, usually a family member, sets aside money, property, investments, or other assets for the beneficiary. The grantor chooses a trustee to manage the assets for the benefit of the beneficiary. The beneficiary has no direct control over the assets and can't spend them. That's the role of the trustee. The beneficiary's needs and desires are taken into account, but the trustee has the final say over how the money is spent. And that's what makes a special needs trust so valuable.
Somebody that is on means-based public benefits can only have $2,000 or less in assets. If they have more than $2,000 in assets, they're going to be bumped off of those public benefits, and that's not a good thing.
Even though the beneficiary doesn't control the assets in a special needs trust, day-to-day, month-to-month spending decisions by the trustee can affect benefits if they violate any of the rules, laws, and policies that apply to benefits. That is where the Arc of Northern Virginia can play a crucial role.
The greatest strengths of the Arc of Northern Virginia is their experience and their expertise in the special needs arena. They're not going to make a mistake in a distribution and bump somebody off of public benefits. The rules in special needs area change constantly, and somebody that is not familiar enough with the special needs arena is not going to be able to keep up to date on those rules.
And that's one reason why more than 1,000 families have decided to entrust those tasks to the Arc of Northern Virginia and our partner, Key Bank. In our trusts, we divide the responsibilities of a trustee in two, adding the role of manager to the mix. ARC team members are experts on day-to-day trust spending decisions. Key Bank's team are experts at managing and growing the money in a trust. Adding the ARC team as manager makes everyone's role easier and adds another level of confidence to the future of the beneficiary with special needs. There are a lot of things trust money can be used for, but there are things it can't be used for. Having experts at the ARC overseeing spending decisions takes a big burden off the family of a beneficiary.
It was very overwhelming to me to realize that I needed to all of a sudden learn about Medicaid, Social Security, Special Needs Trust. Who had even heard of that?
It is impossible to think of all the future needs of your family member. And this offers a sense of security for those who support that family member.
The Arc of Northern Virginia Special Needs Trust team works closely with Key Bank staff to make sure the planning, setup, funding, and operation of every trust runs smoothly. We'd love to talk to you about setting up a trust for you or a loved one with a disability. We serve people in Virginia Maryland, Washington, D.C., and areas beyond. Our trust program is open to people with any disability. Here's how to get in touch.
So these videos are on our website and can be viewed there. That was specific. There's a little bit of a time delay there. We can go to the next slide, Brooke, please. Okay, so who's who? So there are three places you can go to establish a special needs trust. You can go to an authorized nonprofit like the Arc of Northern Virginia. You can go to an attorney, or you can go to a financial institution. Everybody, each of those entities, there will be a trustee. Anytime you have a trust, any trust, you have a trustee. And a trustee is responsible for asset management and asset allocation. So they're investing the money with you and managing the money. They do account reporting because Social Security, Medicaid, HUD, subsidized housing, they may want an account reporting. They have the right to it if the person is receiving services through them. Tax reporting and check writing, dispersing, or ACH transfers, however the money is getting moved out. And then when there's a special needs trust, there needs to be an additional level of understanding in regards to, like the one sister, like Ruth said, Medicaid, Social Security, and all the different benefit programs the person has. With the ARC Trust, we also have a manager. So as mentioned, Key Bank's our trustee and we're the manager. So they do, I kind of look at it like a guardianship program. They're the financial piece and we're the person piece. So we work with day to day with the family members, the agencies, the doctors, dentists, whomever's in their lives. The grantor, it may be different from a trustee with an attorney or financial institution. With us, it's definitely different from the trustee, and that's the person or people that are contributing, establishing and contributing to that trust. The beneficiary is the person with disabilities. In our trust, we have primary representatives. So that's you when you establish the trust, and anyone else you name who may make requests out of the trust and be a main point of contact when you are no longer able or willing to do so. So this is a lot of times where family members will name a sibling, an aunt, a cousin, the milkman, somebody who's a trusted person in that family's life. And if there is no one, then they'll oftentimes name an agency or entity that's providing services to the person instead. The trust that's written through an attorney or financial institution, they may or may not recommend a trust advocate who has a similar role as a primary representative. In our trust documents, we always want to know who has legal authority. The attorney may or may not, they usually do not write that into the trust documents, nor does the financial institution, but you would want to give them a power of attorney document if there was one. And then the remainderment, and that's who inherits when the individual passes away. So you either go to the ARC to write the trust or to an attorney or a financial institution. And just so you know, the financial institutions nowadays have very high minimums because they don't want to be handling special needs trusts. And it's a lot of work. Next slide. So our partnership is a trust team. So our expertise is providing services to people with disabilities. We have an understanding of current benefits eligibility requirements. And that's if you have a private trust, if you establish a trust with an attorney and you're the trustee or co-trustee, you really don't have a lot of work because that trust probably won't be funded until you die. It's the successor trustee when you have a trust through an attorney that has all the work and has to do what we, for example, do as a manager and Key Bank does as a trustee. So they need to have an understanding of current benefits eligibility requirements. They should be following the grantor's wishes of how they wanted the money spent and considering the beneficiary's needs and priorities. We're in a unique position in that we're a nonprofit first and with the mission statement, core values, and principles. We're not just a nonprofit that manages trusts, but we have an entire holistic approach to the people we serve, the programs we offer, and that we're nationwide. And then there's a progressive fee schedule for accounts over $1 million. We have a few of those. The majority of the accounts are smaller though. And then KeyBank takes on that role, right? Asset out, that's the managing the money, doing the account reporting, tax reporting, check writing, dispersing, ACH transfers. When you have a trust with us, if eventually it will be funded with more than $250,000, you may customize your investments. There's a Key has a financial advisor that you may speak to at any given time, no matter the investment amount. And our trust can hold real property, meaning the property the person's living in. It could be rental property, it could be mineral rights. And they also offer what are called in-kind transfers of stock. So you have your money invested with, say, Morgan Stanley, and it says in your will, when I die, I want those same assets transferred to KeyBank and maintain that investment portfolio. Next slide. I know I'm going through this fast. So there are two types of special needs trusts. There are third-party special needs trusts and first-party. Third party may be funded or unfunded. That means there's money in it or there's not. You can establish them with an attorney or a financial institution or a nonprofit, like the Arc of Northern Virginia, so an authorized nonprofit. It's not everybody that can do this. There's a whole process, like a 2-year process to go through before you can even become an authorized nonprofit for special needs trusts. The first party trusts are almost always funded. You establish it only because you have to fund them, and you do it either through an attorney or bank or a nonprofit. Next slide. So the third party, or what we call family funded trusts, those are established by the relatives, the parents, the friends, anyone but the person with a disability. And if you look to the right, how to fund it, it's funded by anyone but the individual with disability. So they don't establish a family funded trust and they don't put their money into it. Okay, that's really important. You can contact the ARC, you can contact an attorney or a bank to establish it. A lot of people fund it second to die when both parents are deceased, but you can fund it sooner. So in a divorce situation, it's whichever parent dies first, for example, they may choose to fund the trust. There may also be, maybe you have selected to fund it when both parents are deceased, but a grandparent contributes to it when they pass away, and that happens before the parents. So that's a possibility too. Okay, good. You fund it through an inheritance. So in that last will and testament where you're naming the special needs trust for the benefit of Joe, right? A life insurance. So the rest are beneficiary designations, a life insurance policy, for example. I have a life insurance policy. When I die, 50% goes to Sheridan's Trust. Sheridan's Trust is named. Personal support family funded trust for the benefit of Sheridan Grace Marsili, and then 50% to the personal support family funded trust for the benefit of Sky Marsili. It's on the beneficiary designation. It could be a transfer from another trust. So if I had a lot of assets, I may have my own revocable trust and have my assets and resources in that. And then when I die, that trust then says what's to happen to my assets and resources. It could be real property, as I mentioned, annuities, contributions from family members. It's never the beneficiary's money again. And when you determine who will inherit when the individual with disabilities dies. So whomever passes away first of my two girls, when there's something left in that trust, it will go into my other daughter's trust. And when she passes away, I've determined who will inherit at that point. So that's something that you need to think about. And these things can be changed. The special needs trust may be amended. So, and we think that's very important because when you're the families in particular that have 2-3-year-olds that are establishing the trusts, they may want to change that remainder beneficiary 15, 5, 7 years down the road, 25 years down the road, right? Because they're so young. And so that is possible to change the remainder beneficiary, is what they're called, the person who gets whatever's left in the trust. Because as everybody ages, things change. So remember that. Anybody but the person with disabilities establishes it. Anybody but the person with disabilities funds it. It has the broadest use of the funds. So it can be used for the primary benefit of the individual, but it can also be used to buy birthday presents or Christmas gifts or things like that. Correct. The special needs trusts are generally not used while the parents are living, although more and more of our trust clients, as the adult child gets older and they want to be teaching them more financial responsibility and financial literacy, they want to teach them how to manage money and spend money, then they may fund the trust with $3,000 or $5,000. And then we work directly with the beneficiary on how to disperse from the trust, how we can transfer money to their reloadable credit card. And whenever those individuals, we see people that are moving out too, whenever they move out, the parents may put more money into the trust, because what they're trying to do is have this build up a comfortable situation for the individual with disabilities. So when the parents are no longer able or willing to manage the money, maybe I want to go to Tahiti for 3 months, right? And I want somebody closer by working with them. Then I want to be confident that the ARC knows them, they know the ARC. And then many, many years from now, when I die, they already know what's going on. They know how to get the money. They know who to talk to. They know how everything works. That's when families will fund it potentially before they pass away. Also, for example, Sheridan's trust, somebody left $12,000 to her trust. So that was funded sooner than later, right? And so she started working with my colleague on dispersing from the trust. So that's the family funded. And they remain open after the person passes away to pay for funeral, burial, or any other expenses that may have arisen that had not been paid for yet. Next slide. This is a little bit on family funded.
Many families set up a special needs trust for a loved one with a disability. That's because a special needs trust does genuinely valuable things that no other structure can do. It provides for a trusted person to manage money and other assets for someone with a disability. It helps maintain eligibility for government benefits based on financial assets. It provides money for things that government benefits don't cover. It helps ensure long-term financial stability after parents can no longer provide care. All special needs trusts come with these benefits built in. Setting up a family-funded special needs trust with the ARC of Northern Virginia comes with additional benefits that our client families love.
We searched around and there really wasn't any other organization that could manage the trust, manage the special needs trust, and help us navigate through the process and help Brandon become more independent.
When I've met the people in ARC, I really trust them. They are just really nice people, and they are the people you can trust. And ARC is a nonprofit organization who has a long history of helping people with disabilities.
I want somebody who understands the person I love and will help them manage that money in an effective way and really ensure that they're maximizing their public and private benefits.
A family-funded trust is a legal arrangement that allows family members, friends, and others to set aside money and other assets for the benefit of someone with a disability. That person, the beneficiary, is the only person who cannot contribute to the trust. A trusted person, a trustee, manages the money for the beneficiary. As a result, the trust funds are not controlled by the beneficiary. That's why the amount of assets in a special needs trust does not affect eligibility for government benefits based on assets. Even before the trust is created, a critical decision is choosing someone to manage it. It's complicated, tricky, and time-consuming. Our solution is to split the duties of a trustee in two. Our team at the ARC of Northern Virginia takes on the role of manager, handling day-to-day spending decisions. Our partner, Key Bank, serves as trustee, minding checks and bill paying, as well as long-term investing. It's a powerful combination, and all of our more than 1,700 special needs trusts are set up with the ARC as manager and Key Bank as trustee. Having two sets of professionals on your side pays off from day one.
I met people in ARC of Northern Virginia. They just showed me how capable they are and how I can trust them and the experience they have. It just make me make the decision that they are the one I'm going to use as the trust manager.
We looked at other organizations to do a special needs trust, and we just didn't feel like they had the body of knowledge that the ARC had.
We'd love to talk to you about setting up a trust for you or a loved one with a disability. We serve people in Virginia, Maryland, Washington, D.C., and areas beyond. Our trust program is open to people with any disability. Here's how to get in touch.
Thank you, Brooke. We have a lot of great resources on the website too as well, so that you know. So the next slide. So that's the family funded trust. That's what we do as part of our futures planning. We're getting everything in place. We're making sure that, God forbid we were to die tomorrow, everything would be set up. But if I die 35 years from now, it's good too. The first party trust, or what we call self-funded, these are the oops, oh no, what do I do now trust, because the person has come into money unexpectedly. So it's often funded through an unexpected inheritance. So Uncle Joe in Montana dies and leaves $20,000 to the individual with disabilities. And if that person has Medicaid and a Medicaid waiver, we've got to move that money right out of their name. Lump sum payback. We had somebody in a group home that was getting supplemental security income. The program manager went in and said, why is he still getting SSI? His parents are deceased. He should have switched to Social Security disability 10 years ago. And they wrote to Social Security and he got an $80,000, $80,000 lump sum payback. And so they said, he sent him on 2 cruises and we bought new bedroom suite and we got him a new recliner, but we can't spend this money. We don't know what to do. And so we moved the money into the special needs trust, because with the lump sum payback from Social Security, only when it's a lump sum payback from Social Security do you have 9 months to spend that down without it jeopardizing the benefits. Any other unexpected form of earned or unearned income counts as income to the beneficiary, counts against the means tested benefits. It could be a jury decision or settlement. So there was an accident, the person sued and they settled out of court or went into court, and the jury decided that money can be irrevocably assigned to the first party or self-funded trust. In their income can be put into a first party trust. Adult child support, military survivor benefit, alimony. We have somebody that's disabled and is getting alimony irrevocably assigned to the trust. And we have a client that won the lottery big in DC, and those funds have gone into a first party trust. So it's the beneficiary's money, right? Remember whose money it was that went into the family funded trust? Anyone but the beneficiary, right? On the self-funded trust, the first party, it's the beneficiary's money. Why do we divide the two? Because on the family funded trust, you determine who inherits when the person passes away. Remember, whichever of my daughters passes first, the other daughter's trust gets the money. On a first party trust, if there's a Medicaid lien, Medicaid has first dibs, and then it goes to the heirs at law. Or if you have a state planning authority and establish it with the ARC, you can leave it to the nonprofit. Not any other nonprofit, only the nonprofit managing the funds. So you never want to open up a family funded trust to a Medicaid payback, right? A Medicaid lien. You keep your money and their money separate. Federal statute also indicates and delineates who may establish the trust, the first party trust, and that's the individual with disabilities if they're not under guardianship, the parent, grandparent, guardian with a capital G, so someone's gone to court and become their guardian. It may be court ordered. We have several trusts where somebody has questioned the trustee and how they were spending the funds, and it went to court, and the court took it out of the hands of the trustee and ordered that a trust be established with us instead, and the funds transferred to us instead to manage for that person. Or it could be an agent under a power of attorney. So here it's specific people that may establish the self-funded trust. Same process, either you come to the Arc of Northern Virginia or you go to an attorney or a financial institution. Again, the banks just want the big bucks, right? They want the millions. Most of them have $1 million minimum. We do not. we don't have a minimum. You only establish this trust if you have to, right? They've come into unexpected money, or if you're military and you're doing your survivor benefit plan, those are when you establish it, right? Before the money is actually in hand. So as you can see, it's very different. The self-funded trust is for the primary benefit of the individual. So it has the family funded trust has the broadest use because it can be spent on the individual, but the individual can also use the family funded trust to buy presents and gifts for others. The self-funded trust is for the primary benefit of the individual, right? It's for their benefit. So it can't buy gifts for other people, but it can buy a huge number of other things. They supplement government benefits, right? So it could be for a vacation, it could be for tennis shoes, it could be for house plants, it could be for dental work, it could be for a dishwasher, etc. Next slide. Might be another video. Yep, I think this is the last video. So there's some repetition here, but it's good to hear it several times.
Expected
You don't hear it.
sounds like good news, and it can be. But sometimes, if someone with a disability gets a sum of money unexpectedly, that windfall could end up being a real problem. Here's why. Some disability benefits programs have an asset limit of $2,000. Having unexpected money come your way could also mean suddenly having more money than a program allows, and that could reduce or interrupt benefits. And even if government benefits aren't a factor, there's a risk the money could be misspent by someone who doesn't manage money well. Either way, unexpected money can be preserved and protected. A self-funded special needs trust with the Arc of Northern Virginia is an effective way to be ready for the unexpected and to have a solid plan for the future. We're experts at managing special needs trusts, and that's why more than 1,700 individuals have their special needs trusts with us.
The greatest strengths of the Arc of Northern Virginia is their experience and their expertise in the special needs arena. They're not going to make a mistake in the distribution and bump somebody off of public benefits.
I think the biggest value that we see as having ARC as the manager is the fact that they really understand all the different needs that Brandon might have. And I think that was huge for us.
Here are some basics. A special needs trust is a legal arrangement that sets aside assets for a beneficiary, someone with a disability. A trusted person, a trustee, manages the money for the beneficiary with a disability. As a result, the amount of money in a trust does not affect someone's eligibility for benefits with asset limits. A self-funded trust is called for when assets are in the name of the person with special needs. The assets might come from an unexpected inheritance or a legal settlement, such as a personal injury award. It could be child support for someone who has turned 18. It could be spousal support after a divorce. Sometimes money comes from the U.S. Military Survivor Benefit Program, or as a lump sum payment of Social Security benefits. And of course, you could win the lottery. There are several people who could set one up. The beneficiary himself or herself, their parents or grandparents, or a guardian can do this. Someone with financial power of attorney for the beneficiary can do it too. At times, the court may order the creation of a self-funded trust. Even before the trust is created, a critical decision is choosing someone to manage it. It's complicated, tricky, and time-consuming. Our solution is to split the duties of a trustee in two. Our team at the Arc of Northern Virginia takes on the role of manager, handling day-to-day spending decisions. Our partner, Key Bank, serves as trustee, minding checks and bill paying, as well as long-term investing. It's a powerful combination, and all of our more than 1,700 special needs trusts are set up with the ARC as manager and Key Bank as trustee. Having two sets of professionals on your side pays off from day one.
The rules in the special needs area change constantly, and somebody that is not familiar enough with the special needs arena is not going to be able to keep up to date on those rules.
It's a very complex process to go through. And when you're doing it on an emergency basis or when you're in a crisis, it's even more stressful.
We'd love to talk to you about setting up a trust for you or a loved one with a disability.
Thank you, bro.
Serve people in Virginia, Maryland, Washington, D.C.
So it just reiterates the difference between the two types of trust, the family funded and the self-funded special needs trusts, and why sometimes there is a need for both of those trusts. Okay. So this just talks about what we do. We educate and plan with the family, prepare the trust paperwork, we facilitate the trust plan preparation. And KeyBank reviews and approves the documents, troubleshoots special situations, they ensure compliance. When you have a trust with us, they'll also review your estate planning documents for free to make sure that they're done correctly. And then when they're funded, we review and process the disbursement requests, ensure that they align with the grantor's wishes, priorities, and beneficiaries' needs. We make sure we have up-to-date documents and trust plans. That's what we call the letter of intent. On our website, there's a trust plan under documents. If you put letter of intent into a search engine, you'll get 1 million hits for a variety of different styles of letters of intent. And we coordinate with case managers and other stakeholders. While KeyBank is the trustee, or if you were the trustee, so this is the work you would be doing if you were your own trustee of the trust or your successor trustee takes over, right? They process disbursements. They have to keep track of the statements from the accounts on a monthly basis, conduct reviews, do the account reporting, tax reporting, investing, and managing real estate. So that's why a lot of people unburden their family members from all of that heavy lifting. Next slide. By the way, I was told I can go to 8:45 because we don't have a lot of questions at this point. So put your questions in the chat if you want me to hurry up. This just talks about where we are. We manage over $43 million at this point. Next slide. So what are our fees? To establish the trust with the ARC, we have a one-time enrollment fee of $1,050. And whenever we establish a second trust, whether it's say a third party and a first party trust for the person, or there are multiple children in the family, like with my kids, we do a buy one, get one half off with BOGO at the ARC of Northern Virginia. So the second trust is half price because personally, I pushed for that since I know how strapped we are raising kids with disabilities. And when you have two of them or more, then it's even more costly. And then on the first anniversary of establishing the trust, we have what's called an annual maintenance fee. Yes, there's still time to address ABLE. We have $65. Or if you wanted to put money into the trust, it's $300. It's seed money, but you don't have to. And when there's $300 or more in the trust, then instead of the $65 annual renewal, it's around $4.48 a year until there's, which is 1.49% of the corpus of the trust. So, you know, on $10,000, that's on $1,000, what, that's $1,490. On 100,000, it's 100. Is it 1,490? I can't do my math right now, but that's a combined annual management and trustee fee that covers the work that we do, and that's competitive with other financial institutions. We've lowered it twice within the last year, and we're negotiating with KeyBank to lower it again. And then the only other fee we have is whenever the individual passes away, or if the trust is about to be depleted, it's $250. To terminate a special needs trust. And that's all we charge. We don't charge for phone calls or disbursements or transfers or FedExing or anything like that. This is our fee schedule, the enrollment fee, and then either the annual renewal or the 1.49%. Next slide. So here's ABLE. So what is the ABLE Act? ABLE is Achieving a Better Life Experience, signed by President Barack Obama on December 19th, 2014. So we just celebrated the 6th anniversary. It authorizes states to create a new category of savings programs for those people with disabilities who qualify. And like special needs trust, the assets in an ABLE account, as long as you comply with the rules, they do not affect eligibility for Medicaid supplemental security income or subsidized housing, although there is a threshold, and I'll talk to that on SSI. It's used only for qualified disability-related expenses or purposes. And the IRS, so it falls under the United States Department of Treasury and the IRS 529 and the IRS. So it was meant to be a transactional account, meaning money in, money out, and a savings mechanism used in addition to, rather instead of, establishing a trust. So every tool in our toolbox has a different use. Next slide. Here's some ABLE facts. I squeezed 10 of them on this little slide, but there's an attachment that will be posted on the DSNMC website that gives you more detailed information. So the onset of disability. For an ABLE account, you have to qualify, the qualifying disability has to exist prior to 26. Not so for a special needs trust, but for ABLE right now, still it's a 26 age limit. Who may establish it? So again, the law says beneficiary at 18 or older, the parent when the child's a minor, the guardian, or an agent under a power of attorney. So someone that has to have authority, an authorized legal representative. They may have one ABLE account. If there are two ABLE accounts for the same person, the second one then counts as an asset. The fees are financial institution fees, so they are relatively low, $25 minimum on the ABLE Maryland, and I think it's $1.25 a month. I can't remember. And they charge for checks, paper copies of statements, but they're all minimal fees. They do add up eventually, but they're minimal compared to, say, the fee for establishing a special needs trust, but they each have different purposes. Yes. And Kalani's going to read me the questions once I get through these slides. Contributions, there's a $15,000 limit, aggregate limit, and then the total one could ever have in a 529. This one still says Virginia, but Maryland is $500,000. If the person has SSI and there's $100,000 or more in an ABLE account, the SSI would be suspended. There are investment options available. The fiduciary decides. So it's Mellon that oversees the Maryland ABLE, and they have either all cash, you can put it all in all cash, or, conservative, balanced, or aggressive. The special needs trust has 8 options, or you may customize investments. So there's different funding scenarios. But both with ABLE and special needs trust, you do have the option of investing. Valid distributions. So they're broadly defined as disability expenses. And there's the next slide, we'll talk a little bit more about that. Taxes. So this is a benefit. The earned income is tax-free as long as you disperse correctly from the ABLE account, meaning for a disability-related expense directly related to the disability. If you do not, then the return on that investment amount, dollar amount that you have there, is taxable. There's a 10% penalty, and it may count against you for SSI and Medicaid. Medicaid payback, Maryland and Virginia both have removed the state Medicaid payback, but there may potentially be a federal Medicaid payback if the federal law requires it. And that's over 55 and on long-term care. So that includes the long-term care Medicaid. Yeah. And then the beneficiary's income, if they're making money, they can contribute an additional $12,490. I should have updated it. It's on my other slide. It's a little bit higher for 2021 of gross income if they're not contributing to an employer-sponsored retirement plan. Yep, next slide. This just tells you the broader categories of what qualified disability expenses are. Like housing and basic living expenses are a loophole, I call that, because you can use the ABLE to pay for those things and it's not reportable to Social Security. Next slide, and then we're going to be done, Kalani. The IRS, whoever's overseeing the ABLE account, so Mellon sends an annual tax reporting to the IRS. The IRS, Medicaid, if the person has Medicaid, Social Security, if they have SSI, as well as HUD, may come back and ask for an account reporting if that person receives those benefits. I talked about the next 2 points. Social Security also receives a monthly accounting by ABLE, and it's strongly recommended to keep records of the receipts in case of an audit, because you never know, they can come back. So just like with the special needs trust, we keep copies of receipts, invoices, and bills. You should be doing the same thing when managing an ABLE account. Next slide. Next slide. Questions? Okay.